Welcome to today's program titled Student Loans and the CARES Act. At this time, all participants are in listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn it over to Tanya Esposito. Tanya, you may begin.
Great. Thank you so much for that introduction, and I want to thank everybody for joining us today for our webinar on student loans and the CARES Act. I'm joined today by a couple of my colleagues, and I'll introduce them momentarily, but I wanted to let everyone who's joined us today know or make sure that you're aware of Seyfarth's COVID-19 Resource Center. We have lots of helpful materials on myriad subjects, including financial services, bankruptcy, and all things related to litigation. And so I encourage you to take a look and register if you're interested, and you can see that the website to do that is located on the slide in front of you. Before we get started, I'd also like to make sure that everyone appreciates that the information we're providing today is for informational purposes only, and so clearly the material and the subject matter that we're going to discuss during the webinar shouldn't be construed as legal advice or a legal opinion of any kind or relative to any specific facts or circumstances. It's really just intended for general information, but if you do have questions that we can help with, we're here to help you, so please feel free to reach out after the webinar. As I mentioned today, I am joined by two of my colleagues. David Bazar is a partner in the Boston office of Seyfarth Shaw, and he is the co-lead of the Consumer Financial Services Practice Group. I am Tanya Esposito. I'm located in Washington, and I'm also in the Consumer Financial Services Practice Group. And we're joined with Bill Hanlon, who is in litigation in Boston, and he's a bankruptcy specialist. So today we're going to cover four main topics as it relates to student loans. We're going to talk about the CARES Act relief that's available to student borrowers. We're going to go over the restrictions on collections activities. We're going to discuss issues concerning repayment in the future and what that looks like. And we're going to end by having a nice, robust discussion of bankruptcy and how that comes into play here. So we're going to start off talking about the CARES Act relief that's available to student borrowers. And so I'm sure that most, if not all of you, are aware of the fact that the Coronavirus Aid, Relief, and Economic Security, or CARES Act, was signed into law on March 27th. And the CARES Act provides for some relief to federal student loan borrowers, and we've detailed all of that here for you in summary form. So essentially, there's a deferral of loan payments available until September 30th, the suspension of actual accrual of interest, again, until September 30th, suspension of involuntary collection until September 30th. And again, all of the suspended payments under the CARES Act cannot be reported as a missed payment. And it allows employers to actually contribute up to $5,250 through the end of the year to each worker's student loan debt tax-free if an employer is offering that benefit to its employee. Finally, Stafford loans and Pell Grants received for an incomplete semester don't count toward the total number of loans or grants the student is eligible for. So again, it's not, there'll be no penalty to the student from the federal loan perspective. I should also mention that the Department of Education made it clear that the forbearance period is actually retroactive to March 13. So anyone who made a payment between March 13 and March 27 could request a refund from their servicer, and those requests would be honored. And it's also worth noting that there was some concern initially on behalf of student borrowers regarding public service loan forgiveness. There was some sort of ambiguity around whether the loan forgiveness that's typically afforded after 120 payments for certain forms of employment would be suspended under the CARES Act, or whether it would require that that particular student borrower start from the beginning, or in some way, shape, or form would be detrimental to that particular loan forgiveness program. And that was subsequently clarified by the Department of Education as well, to make clear that it counts those suspended months, so up to 6 months, count toward the actual 120 payments that need to be made, so it doesn't delay the process or throw it off track at all. So private student loans. The CARES Act does not apply to private student loan debtors. So if a student has private loans, there really is no express relief provided by the CARES Act. It does, however, amend the FCRA, the Fair Credit Reporting Act, and it requires that student loan servicers offering accommodations, meaning any kind of deferral of a payment, don't report any negative activity until at least 120 days after the expiration of the COVID-19 national emergency. Now, similar to mortgages, if the student loan account was in default or was delinquent prior to the enactment of the CARES Act, then that servicer can continue to report that account as being delinquent, but cannot do so subsequent to in relation to a non-payment during the relief period afforded under the CARES Act, which amends the FCRA. It's important to note here that the CFPB has encouraged all private lenders to work with borrowers on forbearance options and other benefits. So several members of Congress have asked private lenders to do a number of things, including suspend payments without fees or any other negative consequences, suspend actual accrual of interest, halt involuntary collection, discharge of debt for distressed borrowers, and expand affordable repayment and loan modification options. And in response, many private lenders are in fact offering relief generally to people who have demonstrated hardships as a result of COVID-19. And so everything we're reading out there suggests that at least 25 major private loan servicers have expressly articulated their intent to assist debtors by doing case-by-case analyses, affording at least a 90-day forbearance, and some have said they're going to, extend that forbearance during the duration of the national emergency. They're waiving late fees, and they're actually affording some rate reduction programs to decrease interest rates and make monthly payments go down. Although most servicers are, as far as we can tell, allowing interest to continue to accrue on some level. So in sum, that's essentially how the CARES Act is affecting the world of student loans. And I'm going to turn it over to David now, who's going to talk to you about restrictions on collections.
Hi, this is David Bazar, and I'm going to cover our portion on collection activity. So states have become very active recently in limiting, or in some instances outright prohibiting, certain forms of debt collection, and not just even consumer debt collection and not limited to student loans, but more generically across the country during defined periods of the COVID emergency, typically as defined by the governors of the states and their proclamations of emergency. Wisconsin has published guidance on ordinarily appropriate debt collection activities that may be considered unfair or harassing during the pandemic. Nevada has Nevada-based collection activities are required to close. Out-of-state agencies licensed in the state must cease collection. Illinois, monitoring inconvenient contact times and places changed by the nature of the pandemic, suspension of Illinois civil procedure provisions that allow service of garnishment or wage deduction summons or citations to discover assets. Washington, D.C., no collection lawsuits, garnishments, seizures, attachments, or repossessions during the national emergency period, and an additional 60 days. Debt collectors cannot engage in any communication under that restriction. New York banks and debt collectors cannot seize stimulus payments under the CARES Act. Massachusetts prohibits debt collection calls, lawsuits, garnishments, or other collection activity during the state of emergency. And the Attorney General has also put out guidance, not on the slide, but that the CARES Act payments, the emergency payments that are coming out from the federal government directly to consumers are considered property that's exempt from seizure under Massachusetts property exemption laws. Minnesota, debt collection workers cannot report to work but can operate remotely, and Texas outlaws wage garnishments. Many states are outlawing evictions and or foreclosures. Massachusetts, in fact, just passed such a law this week. They tend to be coming out on an emergency basis. Many of them are being challenged, or some of them are being challenged in the courts, and our firm is involved in such challenges. And there'll be a lot more to come on these laws. Borrowers are reporting that the Department of Education suspension of collections has not occurred. Tax refunds being seized, technical defaults occurring, and garnishment continuing. However, the Department of Education has contacted employers of over 135,000 borrowers to attempt to stop garnishments, and loan servicers will send letters to those employers who could not be reached. The Department of Education has promised that payments will be provided to those who have had part of their tax refund or wages seized. So with that, we're going to transition to Bill Hambley to talk about the next slide.
Well, that kind of highlights some of the problems that are facing servicers of these loans. With a sudden stop in collections, with a requirement under the CARES Act that auto withdrawals stop, with a crush of people calling in with questions and seeking advice and information, and a patchwork of state law remedies. For instance, the New York State Department of Financial Services supplemented the CARES Act by reaching a agreement with private student lenders servicing loans for about 300,000 New Yorkers, and that agreement imposes a 90-day forbearance on payments, a waiver of late fees, a prohibition on reporting negative credit information to the credit reporting bureaus, but that's only 90 days, and it's a different period, and each state is working on its own remedies, and it's going to be a challenge for the servicers of the loans to keep up with each state's proclamation in addition to the federal government's proclamation. We've got a real practical problem with students repaying their loans as well. You've got a lot of students that faced unanticipated costs, being told to leave campus. You've got students still on the hook for lease payments for their off-campus housing. You've got hiring freezes. You've got summer internships and programs which are being canceled. You've got a tremendous blow to the hospitality industry with closures of restaurants and bars and typical student side jobs and gigs being closed. So you've got a lot of pressure on these student loan borrowers, and it's making it all very difficult for them to make decisions and to get their bills paid. So in this respect, the CARES Act is a real a genuine relief to students who are dealing with the payment of these loans, as well as the co-borrowers who may themselves be facing employment issues and COVID-19 financial pressures. And I think this is going to lead us eventually to bankruptcy. Even with the 6 months of COVID-19 relief and CARES relief, we're going to be looking at a fair number of student borrowers and student co-borrowers filing for bankruptcy. And I don't think it's going to happen real soon. Right now, it seems like the world is trying to hit a giant pause button, and I think this student loan relief that the CARES Act puts in place is a great example of that. The loan payments are suspended, and we pick things up 6 months from now and see where we are. There is not the same sort of stability in other markets, rental markets, private loan markets, and there will be financial pressures which result in a fair number of bankruptcies. The CARES Act made some temporary changes to Chapters 7 and Chapter 13 of the Bankruptcy Code. Chapter 7 is the liquidation chapter, where a debtor files and discloses all of its assets and its liabilities, and a trustee is appointed and liquidates the assets and distributes any non-exempt property to the debtor's creditors. And Chapter 13 is a repayment plan, which typically lasts for 5 years. The Chapter 13 debtor agrees to contribute their so-called disposable income to the repayment of their debts, including their student loan debts. The temporary changes which the CARES Act put in place vis-a-vis bankruptcies are an exclusion from the calculation of debtors' income of any coronavirus-related payments. For example, the stimulus payment, tax stimulus payment of $1,200, which is going out to a number of students and to a number of their co-borrowers, typically their parents. If and when the student or parent gets to the point where they're ready to file for bankruptcy, that income and any other COVID-19 related income will be excluded from the calculations in determining their eligibility to file. And that is important for a few reasons. Both Chapter 7 and both Chapter 13 have debt limits, and Chapter 13 in particular requires a calculation of what is disposable income, and excluding those one-time payments is a very sensible result, and it's one that has been enacted with the CARES Act. Another change that will affect existing bankruptcies is that the CARES Act extends from 5 to 7 years Chapter 13 cases, and that will, it's not automatic, but it's for those debtors that committed to repaying their creditors within a 5-year period and then find themselves stuck, adversely affected in their employment and income by the CARES Act, or rather by the COVID-19, that gives them an additional couple of years to make it up. I think those are all real positive changes. They're all in effect for 1 year, and then they automatically expire. I should mention one other change which will affect some people. The Small Business Reorganization Act, which was passed earlier this year, also had its debt limit substantially raised. So people with student loans who find themselves more deeply indebted than others, and thus ineligible for Chapter 13 relief, may be eligible for Chapter 11 relief if their debts exceed $2.7 million. That cap has actually been raised to 7.5. It would likely apply to people with student loans and small businesses. The one thing that the CARES Act did not change is the standard for dischargeability. And as many of our listeners probably know, student loans are generally accepted from discharge under bankruptcy rules. That means that you can't just file for bankruptcy and get rid of your student loans. They're automatically accepted from discharge unless the bankrupt does something to accept them from discharge, and that's generally speaking filing what's known as an adversary proceeding. It's a little civil procedure within a bankruptcy. And there's been a lot of discussion over the past several years about the ability to discharge student loans in bankruptcy. It started, historically, that student loans were freely dischargeable in bankruptcy. And then there was a perception, perhaps accompanied by reality, but perhaps not, that students could take advantage of this, complete their education, and discharge their student loans. And the statute was changed to require that the debtor couldn't discharge their loans unless they were 7 years past when they finished their education. And then the statute was amended again to cover private loans, and the statute was further amended to accept all loans from discharge. Some commentators have said that has led to an explosion in student lending, but that's the subject of an entirely different webinar. Circling back to the undue hardship requirement, if you file for bankruptcy and you want to get a discharge from your student loans, you have to prove that you will suffer undue hardship by virtue of repaying them. There are multiple court decisions interpreting what undue hardship is. Undue hardship is not defined in the bankruptcy code, but it's generally interpreted as requiring that the debtor has made good faith efforts to repay, has a future inability to pay, and can't maintain a minimal standard of living for himself or herself and their dependents. And that standard is subject to varying interpretations by different courts, often resulting in decisions that feel more subjective than objective. We generally tell debtors seeking a discharge not to be driving a car that's nicer than the judge's. But that aside, it's a difficult standard to meet, and the perception over the last several years has been, no, you can't get a discharge in bankruptcy. And if there's one thing that's for sure coming down the road, it's going to be litigation over whether a discharge is available in bankruptcy and what the correct interpretation of undue hardship is. There are commentators that note that the requirement of good faith repayment could be separately described in the statute, and it hasn't been. And there are commentators that look to other places where the term undue hardship is used in a statute. It's used once in the bankruptcy code, where in the reaffirmation context, undue hardship arises when the debtor's disposable income is not enough to make reaffirmed payments. So what does that mean? Well, bankruptcy provides a discharge, but sometimes a debtor would like to reaffirm a debt. And a classic example is if you need a car and you want to reaffirm that debt, so you're going to keep your car, or if you own an appreciating asset, say a Harley collectible or some other type of asset that is both functional and likely to appreciate, the bankruptcy code allows you to agree with the debtor, agree with your creditor rather, to reaffirm that debt and to keep that debt as part of your your ongoing obligations, even though you would otherwise be entitled to a discharge. And the standard for reaffirmation is that it cannot cause an undue hardship. How is undue hardship measured in that context? It's measured on whether the debtor can afford to make the reaffirmed payments. And there's a presumption that it can't, and the debtor has to show that it can make the reaffirmed payments in order for the bankruptcy court to approve a reaffirmed indebtedness. Undue hardship is also used in other statutes dealing with employment discrimination, dealing with eligibility for Title IV student aid, dealing with extensions of tax payments. And in those contexts, the focus is really on the here and now and the affordability of those payments. The court doesn't look very far in the past, and it doesn't really look very far in the future. It says, what's the situation on the ground now? Can the debtor afford this? And I think the affordability of student loans is going to come to a head in this crisis. because even though a large number of student debtors and their cosigners have been given this suspense period under the CARES Act, there are still millions of loans out there held by private lenders that are subject to this patchwork of state law enforcement and restrictions on exercising remedies, and that may not be suspended as they are under the CARES Act, but rather the debt just continues to accrue, the interest continues to accrue, the bills will come due, and may well result in people filing for bankruptcy, and then people taking a hard look at the affordability of their student loans and whether they can make a case for undue hardship. And I think the courts, particularly given the severity of the economic effects of the COVID-19 virus, and the setbacks that it has dealt students and the disruption in their education, are going to take a very hard look at whether the undue hardship test, as it's been applied, continues to be viable, or whether it should be changed. I also see in the future an increased scrutiny of the text of the bankruptcy code, which deals with the discharge of student loans, and in a broader picture, I could see a number of issues arising regarding the servicing of those loans, particularly post-COVID, where you've got this, you've got the CARES Act on the one hand, you've got this patchwork of state and local restrictions on the other, and you have a potential there for debtors to have real problems with their servicers, and servicers need to be alert to treating their student debtors fairly and in compliance with local and state requirements, and borrowers need to be alert as well and understand what their rights are, and actually look at their statements, figure out, am I getting the right treatment here? Am I getting the forbearance? Am I getting the waivers? Am I getting the correct credit reporting? Because if the answers to those are no, then they're going to be thinking about claims against servicers, and servicers need to be prepared to say, look, we were in compliance because we didn't do this and we didn't do that and we forbeared from doing this, but on the other hand, we didn't have to do the third thing, and this is a private loan and there was only a 90-day forbearance period, not 120, not 180, not a 6-month period. So there's going to be a lot of questions and a lot of litigation, and I think that some of the court systems are already bracing themselves for this. And I think one of the models that I'd like to discuss is the mediation program that the United States Bankruptcy Court for the Southern District of New York put into effect early this year. It was not a COVID-19 response per se. I think the timing is coincidental, but it also is a recognition of the fact that there's $1.5 trillion of student loans outstanding, and that those loans are carried not only by students, but by co-signers who are in their 40s and 50s and 60s, and who may be affected by an economic downturn, and certainly will be affected with the current crisis. We saw a lot of these mediation programs spring up in the wake of the 08-09 Great Recession to deal with defaulted mortgages, and we're seeing them start to spring up with respect to defaulted student loans. And in the mediation program that's been designed by the Southern District of New York, it's designed to facilitate two different types of student loan negotiations. The first is requests for student loan repayment option relief, such as loan modification. And the second is designed to deal with requests for the resolution of disputes over the dischargeability of student loan filing and attempts to bring borrowers and lenders together to have a discussion of this before it goes to litigation. The mediation program is invoked by a debtor in bankruptcy, and the debtor must certify that he has filed an application for a student loan repayment option, and that is basically called up his servicer and asked for a modification, and has experienced a problem with that, either the lack of a response or a response that is inconsistent with what should have been given by the servicer, and that causes that triggers a mediation order to enter, which I'll get to in a minute. The other way that this is started is a claim by the debtor that their student loan is dischargeable under Section 523A8 of the Bankruptcy Code, and that they're not seeking relief because they believe that they're entitled to a discharge. Once the debtor certifies that, there's a process put in place whereby the servicer has to provide the debtor with applications, the debtor has to provide the servicer with information, and they go and they mediate their dispute. And a court-appointed mediator is provided. There is a stay of any motions for relief to go after the debtor or the debtor's assets in the bankruptcy, and there's a stay of any litigation over dischargeability of the loan while the parties communicate with each other and while they mediate. And there are protections put in place for the servicer and for the borrower in those instances. The protections include that communications will not be considered to be a violation of the automatic stay, and the communications are protected as settlement communications under Federal Rule of Evidence 408. the parties are required to mediate in good faith under the penalty of sanctions. If they do reach a settlement, it can be incorporated into a plan in a Chapter 13, or it can be separately noticed and approved by the bankruptcy court under the bankruptcy rules. And it has certain requirements for that settlement, very similar to a reaffirmation practice, where fees, costs, and charges have to be disclosed. The hearing can be waived if counsel represents the debtor and makes certain representations. The agreement needs to be signed by all parties, and the tax consequences of the settlement have to be prominently noticed and set forth in the settlement. Here the concern is that the forgiveness of indebtedness, of student indebtedness, could generate tax consequences for the debtor. And all that needs to be disclosed and put in the settlement. I know that there are other jurisdictions considering this sort of mediation program, and it provides a good buffer to litigation and gives an opportunity for the debtors and the lenders to talk in an environment designed to help them resolve their differences. I think I've talked enough on the bankruptcy issues, and we should probably turn and take some of the questions that have been piling up here. Hey, Tanya, one of the questions that has come in is, should you pay your student loan, even though the payment requirements are suspended? Would you care to comment on that?
Sure. I think that's an excellent question, and I think that that's really a personal question depending on the borrower's financial situation. To the extent that a borrower is in a position to make a payment during the period where forbearances are in place as to the federal loans, I think that making payments would certainly help get the principal down on that particular loan, which, having had student loans myself at one point in my life, I will say that that's a very helpful thing to do when you have a sizable amount of student loan debt. And so, on the one hand, certainly if it's something that you're able to do, it is definitely, something that you might want to consider doing for that very reason. But, on the other hand, if it's not in the cards financially, then it makes perfect sense to take advantage of the flexibility that's being afforded not only for federal loans under the CARES Act, but also as to private loans, where we see that servicers are working with borrowers and being flexible in terms of interest rates and forbearances and things like that. I think that the most important thing is to have those communications with your lender and see what suits you best and what your financial position is, frankly.
Yeah, it may even give students a chance to pay down higher interest loans, such as credit cards or car loans, while taking a break from their student loans and not being charged any interest. Of course, if a student is or a cosigner is thinking about bankruptcy, it may well want to consider paying down dischargeable debt rather than paying down non-dischargeable debt rather than dischargeable debt. So typically your car loans and your credit card loans are dischargeable. Your student loans are not. And if you see a bankruptcy coming in your future, you may want to pay down the loans that you're not going to get discharged.
That makes a lot of sense.
Another question here is what happens on September 30th when the CARES Act suspension period ends? David, would you like to comment on that?
Sure. So the CARES Act has a provision in it. It is 3513, it's 3,513. It's entitled Temporary Relief for Federal Student Loan Borrowers. And that section has the provisions in it that talk about the fact that no interest accrues during this time period when the suspension is in effect. And you can contrast this to the section on mortgage relief, where it used the term forbear instead of suspend. So what the CARES Act means when it refers to suspension of loan payments is that these loans are not actually accruing interest during that time period, and that the interest is suspended, and that the payment obligations are suspended. And then there's a provision about reporting to consumer credit reporting agencies that says that during this time period, says any payment that has been suspended is treated as if it were a regularly scheduled payment made by a borrower. So the consumer credit reporting requirements treat the payment as if it had actually been made. That's all I have on that, Bill.
Great. We've got another question here. Does this also cover the Parent Plus loan? The answer to that is the CARES Act applies to loans that are held by the federal government, and only to loans held by the federal government. It doesn't apply to privately held loans. So in general, it applies to federal family and education loans, direct Stafford loans, direct plus loans, direct consolidation loans, but it doesn't apply to privately held loans. And the best way to figure that out is to identify who your servicer is, and contact your servicer. Other questions that we have here are whether there is any way to negotiate the total due with the Department of Education. I'm not currently aware of any way other than the modification programs which are in place currently and are outside the scope of the CARES Act. Other questions that we've seen are whether payroll can go in and stop deductions. I would say for a federally owned note, you may well have to stop the deductions. But I think that would require some investigation into the source of the loan and who holds it, and that's some information that the employee or borrower can give to you.
I should also, at this time, read the CLE code for everyone who's in attendance. If you're seeking CLE credit for participating today, the code is SS, like Seyfarth Shaw, 7990. Again, it's SS 7990.
And I think that concludes our prepared remarks today, and I'm going to hand it back to our moderator to close things out.
This concludes today's webinar. Thank you for attending.